Obviously a skilled attorney. You took an oath. You're under a penalty of perjury as you speak today. You prepared for today so that you'd be able to answer some of the critical questions, including, obviously, the ones you've been asked so far. Is that correct?
I try and be responsive to the committee's questions, and I appreciate the information that staffers provide about what's of interest to the committee so that we can have the information for you.
So in that preparation, and you've got my old friend Peter Kazik behind you, you prepared to answer questions more or less in about 4 ways. Yes, no, I don't know, or I can't answer, or in some cases some combination of that. That's pretty much how you answer here is affirmatively yes, affirmatively no, or these shades of gray in between, correct?
Congressman, I'm not going to go into the internal discussions.
No, I'm not asking for the internal, but the character of questions.
My responses in that way.
So far today, you have rarely said absolutely yes or absolutely no, correct? You've mostly talked in terms of I can't answer that, or it's not appropriate, or see the FBI director. And so in light of that, and this is really a question of what do I tell the Marines, the sailors, Army personnel in my district, the veterans, the contractors, all those who work for the government with classified information. The former Secretary of State, in an unambiguous way, said repeatedly, both under oath and to the public, time and time again, I did not send or receive any information marked classified. And you're aware of that she had definitively said this repeatedly, right? I
believe her statements are on the record, and I defer you to that.
And I have referred to that. She unambiguously said something which was not true, according to the FBI director. So when you send and receive documents that are marked classified clearly, and according to her statement, 300 people have seen her email. Some portion of those people saw the ones that said secret, top secret, confidential, whatever. None of them are charged. What do I say to the tens of thousands of people that live and work in my district, that work for the federal government, including more than 47,000 Marines? What do I say when, in fact, saying something that isn't true, handling classified information in an extremely careless way, has no criminal ramifications? What do I say to them? How do I reconcile the fact that they know that their friends and colleagues have been prosecuted or fired for doing less in the past?
Congressman, I can't speak to any cases you may be referring to involving friends or colleagues. Again, I would refer you to the description that
I appreciate
provided
that,
about
Madam General, but I've got to ask you a question.
That follow this similar fact pattern. That is what I think we focus on.
Okay, let me go through.
Every case is different.
Every case
has to be handled in the same way. Every individual, whether they are former secretary,
so there will be some cases
has to be reviewed.
Madam General, I have very limited time.
And the law there.
General Lynch, you keep mentioning this professional team of career professionals. Were there any political appointees on that team? Any people who, in fact, did not work for the State Department, or did not work for the U.S. Attorney's Office prior to President Obama coming into office?
Well, again, with respect to the team, typically we don't go into the composition of it. It was led by our National Security Division, and everyone on the team was a career individual.
Again, I'll ask the question with specificity. I'm not asking for names. Was there at least one person who was politically appointed that was on that team?
The investigative team was composed of career prosecutors and seasoned agents.
The question is, was there at least one that did not work a career, that was in fact an appointee, either confirmed or unconfirmed?
Congressman, I've replied to you as to the composition of the team, that all of them.
So your answer is no, there were no political appointees?
All of them were career lawyers as well as seasoned investigators.
Okay. I'll take that as a no, because that's the only way I can interpret what you keep repeating. So, last but not least, the American people are told that these documents were not a crime to carelessly deal with. Should I find a way to make sure that those thousands of documents are made public so the American people can evaluate just how insignificant they are, or how President Obama said there's classified and then there's classified? Are these documents that could be easily made available to the public, or are they too sensitive to be made to the public today?
Congressman, you may take the appropriate steps in terms of reviewing anything, and you may make requests for that, and we'll work to accommodate you with respect to that. I don't have an answer for you beyond that.
So you couldn't today, you could not characterize whether any or all of those documents would have to be retained privately because they're too sensitive to be made public.
The time of the gentleman has expired. The witness will be permitted to answer the question.
Thank you, Mr. Chairman. With respect to the handling of any of the documents or emails in this matter, because they involve another agency, we would have to work with the other agency. We always work with the agency that is termed the owner of information. So on behalf of the Department of Justice, I would not be able to give you an answer at this time as to those documents because it would involve...
After.
I thank the Chairman and Madam Attorney General. Thank you so much for being here. Does an individual need a security clearance to review or have access to classified material?
Congressman, that issue will be dependent upon the agency for whom they worked and the nature of the work that they did. With respect
Can you give me an example where you don't need a security clearance to view classified material?
No, I believe, as I was going to say, they would, but the type of clearance varies with every agency, and the agency would make that decision and determination.
Is it legal or illegal to share classified information with somebody who doesn't have a security clearance?
Congressman, it depends on the facts of every situation. You'd have to determine how that sharing occurred. You'd have to determine the means. You'd have to determine, the reason, the intent. Certainly, depending upon how you view the statute, it could go any number of ways.
So you think there is a scenario in which you could share classified information with somebody who doesn't have the requisite security clearance?
No, I would not draw that conclusion. I would say that I'm not able to answer it as a hypothetical, but that there are a number of factors that would go into the decision, and one could have any number of results.
Is it legal or illegal to provide access to somebody who doesn't have the requisite security clearance to view classified material?
To provide access?
Yeah.
Again, I'd need more facts on the hypothetical, but I would look at a number of things, and depending upon how you reviewed it, it could go any number of ways.
Is it legal or illegal to store, house, or retain classified information in a non-secure location?
Again, I would refer you to the statute. One could, in fact, have liability. Again, depending upon the nature and facts and circumstances.
Do you have any examples of where it's legally acceptable to retain classified information in a non-secure location?
I don't have a hypothetical answer for that.
Is it legal or illegal to provide false testimony under oath?
There are a number of statutes that cover that, both at the federal and state level. There are a number of ways in which that could be found.
There's a difference between prosecuting something and whether it's legal or illegal. These questions are pretty simple. And we've got millions of people with security clearance. How are they supposed to go through the gyrations that you've laid out in order to make a simple determination?
Congressman, if we had a specific fact situation or fact pattern, that could be reviewed.
I'm just asking,
when it comes to a hypothetical situation, it would be unfair to come up with a blanket answer to someone without reviewing all the facts of their situation.
I'm asking if it's legal or illegal to share classified information with somebody who doesn't have a security clearance.
Again, I would refer you to the appropriate statutes, and I'd refer you to the facts of every situation. It would be unfair to give a blanket answer to every hypothetical.
Why aren't we telling all the federal employees and contractors who have access to classified information, those in our military, why aren't we telling them, you can't do this, it's against the law? Why can't you say that?
We give them guidance. Again, every agency does. We give them examples. We give them information as to how to make those decisions. We show them. And again, every information provides, every agency provides
why is
that.
the law not sufficient guidance? You believe, is there a flaw in the law? Or is there a suggestion on the law?
I don't have a comment on the state of the law. My answer is that
somebody asked me to consult an attorney, and you are the Attorney General. And I think you're sending a terrible message to the world, to those people who are trying to make some simple decisions. the lack of clarity that you give to this body, the lack of clarity on this issue is pretty stunning. These seem like simple issues. Let me ask you, the team that you talk about in the Secretary Clinton email scandal, outside of the FBI, who was on that team that you referred to that made the recommendation?
As I indicated before, they would be career prosecutors.
Okay, so they're prosecutors. Anybody else on the team that was a participant in the investigation?
Not to my knowledge. I'm not sure if you're referring to anybody else. Can you give me some further context for that?
I don't know, like if they go back and do security clearances, determine classification, whether it's secure or non-secure, I would think that there'd be somebody outside of the FBI that would help you make those determinations.
Well, the Department of Justice team would be Department of Justice employees.
I'm trying to ask
respect
specific to which departments within the department. I mean, Department of Justice is a large organization, right? FBI is part of that. Prosecutors are part of it. Who above and beyond prosecutors in the FBI was involved in this investigation?
As I've indicated before, the DOJ team was composed of the career lawyers and seasoned agents in there. I'm not sure if you're asking about
I didn't
something
know if there was
outside
another
of DOJ.
unit or other people that were part of it. That was my question. My time has expired. I wish I had about 20 more minutes. Thanks, Mr. Chairman. Yield back.
Some realities of a dual-track or two-tiered justice system. And I know that you have dedicated your career to the pursuit of justice. I know you work for a blindfolded woman who's holding nothing but a set of scales. And I think it's important that she's blindfolded because she shouldn't see the race, the gender, the socioeconomic status, the fame or lack of fame of the person in front of her. And I'm sure you've experienced it like some of the rest of us. It's not just the suspect or the target or the defendant. The witnesses have to have confidence in the justice system. The jurors have to have confidence in the justice system. The public has to have confidence in the justice system. So this dual track, different set of rules for certain people than for others. It frankly should not matter whether you are running for president or running late to a kid's ball game. The same rules ought to apply to everyone. So let me ask you this. Why do you think it's important to use official email to conduct official business?
I believe it's important to do that. I think that certainly every department has chosen to craft the way in which they carry out their business, and it provides for a way of doing business in a secure system.
So you use official email to conduct official business?
Yes, sir, I do.
Okay. And do you ever email, send or receive classified information on personal email?
I do not.
I doubt you even use your USDOJ.gov account to send classified information, do you?
We have separate systems.
Right.
So there would be a separate
classified system
for that.
Right. So not only do you not use personal email to do it, you don't even use your USDOJ.gov. You have a separate, dedicated system to handle classified information. Why?
We have a separate system to handle the security needs.
But my question is why? Why is it important enough to you to not use personal email to conduct public business and to use a separate, more safely guarded system when you do handle classified information?
That is the practice that I've certainly always followed. It
But it's
allows
not
for the
just
protection.
it's not just a personal preference, is
No,
it?
it allows for the protection of the information, both on a regular system, because again, that's still sensitive, law enforcement types of matters, and then a classified system for separately classified information.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton?
So let me again, as I've indicated before, and I want to make it clear that. As I indicated before, while the reason why I will not be going into the analysis that was provided in the discussion that we had between myself and the team is because we protect our teams and that they have to be free to provide information and analysis in a confidential way without the fear or impact of there being a political influence on that.
I understand
and that is why
that.
I have not gone into that type of discussion. What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute to determine whether the elements had been met.
But my specific question to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint?
Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Don't you think
Yes.
public perception in a single track justice system is important enough that you could at least touch on what you thought was lacking?
Congressman, in this case, we have taken the unusual step of discussing it in ways that the department typically does not, in order to provide more clarity into this situation. And while I understand that it is frustrating to a number of people, civilians as well as members of this body alike, we have taken extraordinary steps to discuss this matter in ways that typically we do not,
Let me ask you
particularly when
this.
charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any
With all due
kind of
respect, Madam
political
Attorney General,
influence.
you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally?
No, just as a prosecutor. There's involuntary manslaughter. There's reckless homicide. There's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual steps of providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
Well, I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to. But right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did or whether
Of law.
After your meeting with Bill Clinton, you were asked in an interview about the appearance of impropriety and said, no matter how I view it, I understand how people view it. It has now cast a shadow over how this case may be received. Do you remember saying that?
That was a few days afterwards in an interview, yes, sir.
We know that you made the decision at that point not to recuse yourself from this investigation. 2 days after you made that statement about casting a shadow on the integrity of the Department of Justice, the New York Times reported that, quote, Democrats close to Mrs. Clinton say that she may decide to retain Ms. Lynch, the nation's first black woman, to be Attorney General, end quote. Did the timing of that, right after the Bill Clinton meeting, give rise to any thought in your mind of reconsidering whether or not recusal in the light of appearance of impropriety might be appropriate?
Congressman, I have no knowledge of the source of that statement, nor have I had any conversations about that.
Didn't give it any thought?
My view was that I needed to discuss the conversations I had with the former president to clarify my role in the investigation.
So I don't want to impugn your integrity by asking you whether the prospect of future employment as Attorney General in a Hillary Clinton administration influenced your decision whether or not to recuse yourself or influenced your final decision regarding prosecution. But now that you've already made that decision and closed the matter, will you consider serving as an Attorney General in the Hillary Clinton administration?
Congressman, my focus is on serving as Attorney General in
No,
this
I don't care
administration.
about your focus. What I want to know is, will you rule it out?
That is my focus now.
You won't rule it out.
It is working on the issues
Will
before
you
the
rule it
Department
out?
of Justice. That
Okay,
matter is
so-
not before me.
Well, I got to tell you, that shadow that you cast on the Department of Justice just got a whole lot bigger. Because if you're not willing to rule out future employment in the Hillary Clinton administration, what that means is the American people have every right to wonder whether or not you looked at this through a fair and impartial lens, because your answer tells the American people that after the FBI director told you that Ms. Clinton had been extremely careless with at least 110 emails marked as top secret, secret, or classified and may have jeopardized the lives of actual Americans, and told you that she made numerous false public statements about sending, receiving, or turning over classified materials, you might want to apply for a job with her? Your answer,
no
not
comment on
ruling
that.
out employment with her, means that as much of the free world is wondering whether or not Hillary Clinton should have been prosecuted and possibly sent to prison for being extremely careless, as the FBI director said, with hundreds of top secret, secret, and classified emails, you're telling the American people watching today that instead of going to jail, faced with the prospect of possible future employment, you think she should go to the other end of the spectrum and be eligible to be the person with greater access and greater control over America's most sensitive and trusted national security information than anyone else on the planet? I got to tell you, utter shock is an understatement with respect to what I just heard you say. So let me ask you this question.
Well, Congressman,
I want to ask you this way. My time is limited and the clock is moving. Based upon your unwillingness to rule out future employment, in light of the fact that you and your husband had a 30-minute conversation with the spouse of a pending federal investigation, the subject or target of a pending federal investigation, and with a person who would be the subject or target of the federal investigation, if there is one into the Clinton Foundation, would you at least agree with me that if there is such an investigation, you'll have to recuse yourself from that one?
Congressman, with respect to other matters before this committee or any other, or before the Department of Justice, they'll be reviewed like any other. I will take all the appropriate action that I would need
I'll
to take
take that as a no.
in that instance.
And let me move on,
And Congressman, as
because
I've
I've got a
indicated to
really
your colleague,
important...
just as I will not comment on the statements of
Listen,
candidates
with
or
all due
candidacy
respect,
of
I'm not going
anyone,
to let you run out the clock on the
either
American
side,
people that
I
have
would not
questions that
comment
need to
on
be
the
answered. So
candidacy
let me move on.
the other one.
On July 5th, 1 week after your meeting with Bill Clinton, FBI director made an unprecedented, extraordinary public recommendation not to indict. But his statement was just a recommendation. You've said, I made the decision. And in his statement to the press, he said that what that decision would include would be considerations like the strength of evidence, especially regarding intent. He said also that a responsible decision would consider the context of a person's actions. So my question to you is, as you made the decision, did your final decision weigh the strength of the evidence and the context of Hillary Clinton's actions?
I will tell you, Congressman, that that was part of what the team that was presenting to me was focused on, and it was certainly encompassed those issues as well as all of the other issues that I've indicated before that would be in that. It would be contained within their entire recommendation to me.
And that was reflected in your two-sentence statement that starts out late this afternoon. I met with FBI Director Jim Comey and career prosecutors. By the way, how long did that meeting last?
Yeah, I don't recall.
Hours?
I don't recall, and I wouldn't be providing that information.
More than hours?
I don't recall and would not be providing that
late
information.
in the afternoon. I assume it was in one day?
It's clear from the statement when the meeting occurred.
Okay, so it happened the day after, and apparently within a matter of hours, if it happened in one day. So you just told us that after a year-long investigation involving 150 FBI agents working around the clock, involving more than 30,000 emails, tens of thousands of man-hours, that your thoughtful, careful weighing of strength of the evidence took you an afternoon, a cup of coffee with the FBI director, that your decision in this case for charges relating to a person who, according to the FBI director, said was extremely careless handling America's most sensitive national security matters and is seeking to be a candidate in charge of America's most sensitive national security matters, took the better part of an afternoon. It didn't last weeks, didn't last months, didn't take days. You weighed that evidence, determined her intent and gross negligence in a matter of hours. Will you at least tell the American people whether or not you at least reviewed the 110 top secret, and classified emails that we know that she sent and received on an unsecure, unauthorized server? Will you at least answer that?
As I have indicated...
Time of the gentleman has expired. The witness is permitted to answer the
Thank
question.
you, Mr. Chairman. As I've indicated, I received a recommendation after a briefing from the team, which included the career lawyers as well as the FBI director. I received a full and thorough briefing. We reviewed and discussed the matter, and I accepted their recommendation. And as I've indicated earlier, again, just to be clear, the reason I do not go into these internal meetings is because the teams of prosecutors and agents who work on every matter need to be able to provide their full and unfettered advice, counsel, discussion, without the fear of political overtones, without the fear of that kind of
Since you didn't
influence.
answer that question, I'll give you a preview that I'll ask Director Comey that when he's in front of Homeland next week. And let me just close then, summarize by saying, so less than after a week after you met privately with the spouse of a target of a federal investigation, a target with whom you haven't ruled out applying for a job, you didn't recuse yourself and instead spent a grand total of a few hours reaching a decision regarding tens of thousands of documents involving our national security, and you can't seem to understand why the American people, Republicans, Democrats, and independents are outraged at your actions. If you thought the meeting that you had on the tarmac with Bill Clinton cast a shadow over the integrity of the Department of Justice, what I've heard today from you made the size of that shadow something that I will tell you that as far as casting shadows that the American people pay attention to, Punxsutawney Phil's got nothing on you. I yield back.
She said, I'll accept the recommendations of the FBI. Mr. Comey didn't announce his decision until July 5th, and he said that he didn't talk to you beforehand. Now, I assume it's not unusual for the Attorney General to accept the recommendations of the FBI and the career prosecutors and the team, as you've so often cited. What is unusual is to make a big, bold public announcement that you're going to do it. It's one thing to do it. I assume it happens all the time. It's another thing to announce ahead of time you're going to do it. So here's what I'm having trouble with, and I guess a lot of people are having trouble with. If you commit and announce that you will abide by the FBI's decision before they even finish their investigation, then how can you also say ultimately it was your decision?
Well, Congressman, as I've indicated, I accepted their recommendation. I had indicated.
So are you? What I want to know is, was it not your decision, or was it your decision? Because it seems to me you can't have it both ways. You can't say I'm the Attorney General and I decide, but yet I'm going to take their recommendations even before they make their recommendations.
I had indicated that I would be accepting their recommendation because I wanted to make it clear that any conversation that I might have had with the former president would have no impact on the team or their review or the investigation.
You ever do this before?
I have not had occasion to do that before, but I felt it was important.
So you've never announced before an investigation is done that whatever they come up with, maybe they're going to screw it up, who knows? You've never announced before that whatever they recommend, I'm going to follow. Never happened before.
It was important in this case to do so.
So this is the first time you've ever done that. Announced beforehand, I don't care what their recommendations are, by golly, I'm going to follow them.
I have complete faith in the judgment and the hard work of the team.
I'm not questioning whether you have faith in them. I think probably a lot of people have faith in the FBI in a lot of situations. I don't know that they agree with them here, but I think they have faith in a lot of times. What I'm questioning is why announce ahead of time? When you've never done it before, why announce ahead of time? I'm going to follow their recommendations, even though I don't know what they are, and still claim you're the ultimate decider.
Well, as I indicated, I felt it was important to express my role in the investigation, to clarify my role, because I was concerned that the conversation I had with the former president would make people think that there could be some influence.
So that was the trigger.
That, in my view, was something that needed to be clarified. I felt that people needed to understand my role.
So you've never done this before, but when you have a conversation with the former president, the husband of the subject of an ongoing investigation, and you have that conversation before they've interviewed the subject and before they've reached their recommendations and finished their investigation, that's what triggered you to do this thing you've never done before, which is announce, I don't care what they recommend, I'm going to follow it.
My concern was that the conversation that I had with President Clinton would be seen by some as having an influence over that. I felt it was important to clarify.
Just some, General Lynch, a lot of people.
And I felt it was important to clarify that even before I had landed in Phoenix, I made that decision.
Here's what I see
felt
happening
it was
here.
important that people hear that from me.
Here's what I think is, I think your actions made it worse. I really do. I think a lot of people already think that there are two systems, as many have talked about, one for we the people, a different one, entirely different one for the politically connected. your former Secretary of State, your former Senator, your former First Lady, your nominee for President, your husband meets with you 5 days before a decision is announced. Different standard for those facts. And you proved it. You demonstrated that it's different by your actions because you said you've never done this before, so you not only you changed your internal practices. You changed the fact that you've never announced beforehand that you're going to follow recommendations before you even have the recommendations. Your actions contribute to this belief that the system is rigged. And that, you made a bad situation worse by saying, I'm going to do whatever they recommend, even though I don't know what the recommendations are. I don't know anyone who would conduct themselves that way when they're the ultimate decider. But you said, I'm going to wait. I'm going to do whatever they said. I'm not even going to wait to see what they're recommending. I'm going to follow it. You showed that this case was different, and the law is supposed to treat every single person the same. And your announcement, by definition, made this thing entirely different. And then, of course, what was ultimately decided made it entirely different as well. I yield back.
Simply an outrage. I won't say that about the recommendation, and you talked about the briefing team, and you said you saw no reason not to accept the recommendation of the team. How much time did you spend reading the recorded testimony of Hillary Clinton from that 3.5-hour interview?
Congressman, I'm not going to go into the particulars of my briefing, except to say that...
No, this is just your own personal work. Did you go through in detail all of the statements she made in that 3.5-hour interview?
Congressman, as I've indicated previously, my role that I had decided earlier was that I would be speaking and meeting with the team who had done that substantive in-depth work for over a year, that had worked on this matter, that had compared the facts and the evidence.
Now, you've said that several times, Attorney General, and I don't have enough time to have you keep repeating that 4 more times. But when Chairman Goodlatte asked you about the statute and whether it includes the term gross negligence, you made an improper statement. You said discussion of the statute would require discussion of the facts. That's not true. From my years of judging on the bench, your comment that discussion of the statute would require discussion of the facts, when he asked you about an element that's contained in the statute, Attorney General, that really sounds like an answer somebody would give who hadn't read the statute and was looking for a dodge to avoid talking about a statute with which they're not familiar. You are aware, and this doesn't require any discussion of any facts whatsoever, but you are aware that in 18 U.S.C. 793F, gross negligence is an element of the offense. Are you not?
Congressman, I refer you to my statement that you just commented on with respect to
well, if you're not going to answer the question, I'm afraid you may be reinforcing it.
The question to me was the meaning of a phrase.
Now, you said there was no basis not to
manner.
accept the recommendation of our team, but you've given no indication whatsoever that you did any independent reading of the evidence, of the statements. Was Hillary Clinton's statement even recorded?
Congressman, I'm not going to discuss the specifics of that. I believe the FBI has provided extraordinary clarity and insight into that.
Okay, well, if you're not going to answer the question, then let's move on. But I find it extraordinary that after a 3.5-hour interview, so quickly a recommendation is made. So there are inquiring minds that are very intelligent that have said, wow. It almost sounds like on that plane somebody said, look, if you just tell Hillary to come in, we're wrapping up, but we got to be able to say that we interviewed her. It won't be recorded, so she'll be good. It sounded like it was a check the box. You're familiar with Scooter Libby's case and Martha Stewart's case. I know it was well before you came to office, correct? You remember they were prosecuted for making a false statement when the FBI and the Justice Department couldn't make the case they started out. You remember that?
One in New York and I believe one here.
Right.
Here meaning
And
DC,
so
sir.
that's a pretty common instrument to be used. If someone makes a statement somewhere inconsistent in what they tell the FBI, that itself becomes a matter of prosecution. And I am shocked. I thought it would be weeks before an answer could be made, but it looks like to do a 3.5-hour interview, you haven't reviewed the facts, you reviewed the team recommendation, and I would just encourage you, Attorney General, your oath was not to follow the recommendation of some team. Your oath is your own responsibility to our Constitution and those that are working under you. My time's expired.